Welcome or welcome back. If you're new here, I am Nick. I 30 years plus as a union rep and a few years in the European Parliament as a documents analyst. Today our saga of Amber Heard continues, this time with the case where her insurance company, New York Marine, has sued her because, well, she was deemed liable for defamation. And since that was done in malice, New York Marine Insurance claims that we don't have to pay, because the insurance was against defamation, to defend her in defamation cases. But if you can't buy an insurance and then use it as a shield. For instance, you can't buy a fire insurance for your house, then burn it down yourself and claim they have your insurance have to pay. That's not how it works. Same thing here. You can't buy an insurance against a defamation or for defamation claims and then go on defaming people. That well, this case has gone on for a while, where a bit of back and forth between New York Marine and Miss Heard, where New York Marine is suing Miss Heard, and Miss Heard has made some counterclaims. And now the court has come back with a tentative ruling. That means it's the judge tells the parties that this is how I probably will rule in this case, unless that the part is make some haymaker out of the blue to save their claim. In this case, it is Miss Heard's counterclaim that is in jeopardy. Let's read it. United States District Court, Central District of California. Case number blah blah blah. Title: New York Marine and General Insurance Company versus Amber Heard. Proceeding. In chambers. Tentative ruling on plaintiff and counter-defendant New York Marine and General Insurance Company's motion to 1. Dismiss Heard's counterclaim pursuant to Rule 12b-6, or 2. Alternatively, for a more definite statement pursuant to Rule 12e, and 3. To strike certain allegation pursuant to Rule 12f. Attached hereto is the court tentative ruling on plaintiff counter-defendant's motion, set for hearing on March 13, 2023 at 8:30 a.m. So the hearing is on March 13th. That is Monday at 8:30 in the morning. Miss Heard and her lawyers don't have much time to find that haymaker to get the judge to change his mind. Let's read. New York Marine and General Insurance Company filed this declaratory relief action against Amber Heard on July 8, 2022. The operative pleading in New York Marine's case is its first amended complaint, FAC, filed 3 days later. Heard filed an answer to New York Marine's FAC and counterclaim on November 21, 2022. She then filed a first amended and supplemental answer to New York Marine's FAC and a counterclaim on January 13, 2023. The FACC contains 2 counterclaims, one for breach of contract and one for tortious breach of the implied covenant of good faith and fair dealing. It includes the following allegations. Heard was the defendant in a lawsuit filed by her ex-husband, Johnny Depp, in Virginia State Court, wherein Depp alleged that Heard had defamed him in a December 2018 Washington Post op-ed. In June 2022, the jury in that lawsuit returned a verdict against Heard on 3 counts of defamation. Heard appealed the judgment before the lawsuit was finally resolved, pursuant to a confidential agreement. That would be the settlement, where Amber Heard paid Johnny Depp $1 million through her insurance for resolving. Well, she paid her fee, or what you call it. Now the verdict in the Virginia court still stands. That settlement made the verdict finalized. If someone tells you otherwise, they are morons. Let's continue. Heard is a named insurer short of a policy New York Marine sold for the period July 18th, 2018 to July 18th, 2019. That would be a few months before the op-ed. She bought this insurance. Now, I don't know how common it is to buy an insurance against defamations months before you go out and defame someone. But that tells me that she knew that what she was about to write would cause some ruckus. And it did. Congratulations, Miss Heard. What do you call it? Don't ask questions unless you know the answer, and well, I will find a good saying for it. Let's go back. Though she asserts that to the extent not waived or otherwise excused, she complied with all terms and conditions contained in the policy. Heard alleges that despite timely notifying New York Marine of Depp's lawsuit and asking New York Marine to defend her, and despite New York Marine's promise to do so, New York Marine actually did not provide the full and capable defense to which she asserts she was entitled, failed to pay attorney's fees and costs she believed it was obliged to pay for her defense, and acted in other ways she contends prejudiced her and her defense. More specifically, New York Marine initially agreed to defend Heard subject to a reservation of rights, but New York Marine never fully paid for Heard's defense, leaving her to incur hundreds of thousands of dollars in defense costs, withdrew from Heard's defense, and expressly repudiated its duty to defend Heard. According to the FACC, New York Marine reserved rights to deny coverage on the ground that Heard behaved intentionally, and Heard asserts this created a conflict of interest that gave her the right to independent counsel, which New York Marine obligated to pay for the fees and costs of this independent counsel. But New York Marine refused to defend her through the independent counsel and instead appointed its own counsel. New York Marine also refused Heard's request to reconsider this position, a position which Heard alleges made it impossible for her to fully accept this defense without prejudicing her defense in that lawsuit. Now this is interesting, because if you have followed this case, the insurance case, that Miss Heard first hired a counsel. New York Marine approved of that counsel. Then, this is before the before the trial, well before the trial, months before the trial. Heard appointed Elaine Brederhoff. She hired Brederhoff and that firm as an independent counsel, while she had the original counsel. And so, in my opinion, if you have a counsel that is working for you, you might not like what that counsel is doing. And you have every right to hire additional counsels. But do you have the right or privilege to make your insurance companies pay for everything just because you didn't like the counsel you hired and they approved? And that's the center of this lawsuit. In my opinion, I would have to bleep that out. New York Marines appointed counsel ultimately withdrew on November 20th, 2020. New York Marine thereafter agreed to participate in Hurd's defense by reimbursing Hurd's defending insurer, Travelers Commercial Insurance Company, for some of the amounts it had paid or was paying towards Hurd's defense in Depp's lawsuit. But New York Marine has not done so. Remember, this is the claims that Hurd and her lawyers are making. That doesn't make them true, but that is what they are claiming. Moreover, once judgment had been entered in Depp's lawsuit, New York Marine took the position that it need not defend Hurd, even though that judgment was not final, and New York Marine still had the duty to pursue and fund an appeal on Hurd's behalf. Summing up her theory, Hurd asserts that refusing to provide the defense to which she was entitled in the Depp lawsuit, and by wrongfully asserting that she was not entitled to indemnity for any amount that she might be legally obliged to pay in any judgment in or settlement of the Depp lawsuit, New York Marine wrongfully repudiated and refused to perform its duties. That's a good summary of Hurd's claims. Let's continue. In addition to this alleged breach of its duties under the policy, Hurd alleges that New York Marine breached the covenant of good faith and fair dealing implied in the policy, not just by refusing to fully and properly defend Hurd, repudiating that duty, and refusing to indemnify her to its policy limits as to any judgment in or settlement of Depp's lawsuit, but also by 1. Failing to fully inquire into possible bases that might support coverage for the lawsuit, asserting grounds for limiting coverage that it knew were not supported by, and in fact were contrary to the terms of the policy, the law, insurance industry custom and practices, and the facts. 3. Taking coverage positions that are contrary to a reasonable expectation of coverage. 4. Giving greater consideration to its own interest than to hers. And 5. Failing to have appropriate claims handling guidelines and failing to consider and act in accord with the governing legal requirements. How do I make that short? I want you to pay! Yeah. New York Marine has now moved to dismiss Hurd's FACC pursuant to Federal Rule of Civil Procedures 12b-6. In the alternative, New York Marines asked the court to order a more definite statement in certain regards pursuant to Federal Rule of Civil Procedures, and to strike various allegations and paragraphs pursuant to Federal Rule of Civil Procedure. This court will begin its discussion with the Rule 12b-6 aspect of the motion, because resolution of that aspect narrows the other live issues presented by the motion. And now we are getting into the good stuff. A bit, at least. It gets really, really good here. Yeah. Am I gloating? Yeah. Because the amount of damage Miss Hurd has caused the Me Too movement, the amount of damage she caused Johnny Depp, the amount of damage she caused Mr. Depp's children. Remember, if you don't know, Depp's daughter was very good friends, almost best friends with Clara Delevingne, and Amber Heard fucked her. So Amber Heard fucked her stepdaughter's best friend. And there are still people out there that thinks Amber Heard was the abuser. Let's get back to this. Rule 12b, standard. Under Rule 12b, a court must 1. Construe a complaint in the light most favorable to the plaintiffs, and 2. Accept all well-pleaded factual allegations as true, as well as all reasonable inferences to be drawn from them. The court need not to accept as true legal conclusions merely because they are cast in the form of factual allegations. You will see why that quote is in there. Dismissals pursuant to Rule 12b is proper only where there is either a lack of cognizable legal theory or the absence of sufficient facts alleged under cognizable legal theory. Dismissal for failure to state a claim does not require the appearance beyond a doubt that the plaintiff can prove no set of facts in support of its claim that would entitle it to relief. However, a plaintiff must also plead enough facts to state a claim to relief that is plausible on its face. A complaint does not suffice if it tenders naked assertions devoid of further factual enhancements. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. In its consideration of such a motion, the court is generally limited to the allegations on the face of the complaints, including documents attached thereto, matters which are properly judicially noticeable, and documents whose contents are alleged in a complaint and whose authenticity no party questions, but which are not physically attached to the pleading. However, a court may also consider evidence on which the complaint necessarily lies if 1. The complaint refers to the document, 2. The document is central to the plaintiff's claim, and 3. No party questions the authenticity of the copy attached to the motion. Summary of New York Marine's Rule 12b6 arguments. New York Marine argues that Heard counterclaims failed to state claims because 1. She had no right to be appointed independent counsel, whether because of what was contained in New York Marine's reservation of rights letter or otherwise. 2. She has not alleged that any of the expenses plaintiff incurred were incurred at New York Marine's request, as the term of the policy requires. And 3. She received a defense from Travelers, her other insurer, and according to New York Marine, an insured defended by one insurer cannot state viable claims for breach of contract or bad faith against another insurer which allegedly did not also provide a defense. New York Marine asserts that it did, in fact, appoint counsel for Heard's defense, the same firm and attorneys that Heard herself had retained months before tendering her defense to New York Marine. Heard does not deny that New York Marine at least initially defended, or at least attempted to defend her in this regard. New York Marine argues that once Heard refused to fully accept that defense, because of her belief that she was entitled to independent counsel, it was relieved of its duty to cover any additional defense costs. It relatedly asserts that Heard was also not entitled to reject the defense New York Marine proffered on her behalf and to demand independent counsel instead. C. Duty to provide independent counsel. It appears to the court that Heard's breach of contract, failure to defend, failure to cover expenses, counterclaim rests entirely on the success of a theory that New York Marine was required to provide her with independent counsel and could not fulfill its defense duties simply by appointing the Cameron McAvoy PLLC firm, the firm that Heard herself had already retained before tendering her defense to New York Marine. What did I tell you? Heard certainly does not appear to deny that her theory for why New York Marine breached its policy obligation to pay for her defense relates to its refusal to provide her with independent counsel. If this is not correct, Heard should make this clear to the court at oral argument on the motion. That oral argument is on Monday. I hope you are seeing what I'm reading, seeing what I'm seeing here, where the judge is leaning. And not towards Miss Heard. Let's get back to this. New York Marine argues that it had no duty to appoint independent counsel, both because the Depp suit was litigated in Virginia and Heard was being represented by Virginia lawyers New York Marine had appointed, and because New York Marine's reservation of rights letter did not create a conflict of interest that would give rise to such a duty, irrespective of the locus of that lawsuit and the duties governing the lawyers litigating it on Heard's behalf. This court has already decided that issue, albeit in a lawsuit to which Heard was not a party. That was Heard bought 2 insurance policies. Because why settle with one insurance if you can have 2 that competes against each other? My guess is that she thought she could play them out against each other if things went sideways. It didn't. Let's go back. This court already determined, as a part of litigation between Travelers and New York Marine, that those are the 2 insurance companies, Travelers and New York Marine. That because the Depp lawsuit was proceeding in Virginia, and because New York Marine provided Heard with a Virginia lawyer, there could not be a conflict of interest. In reaching that conclusion, the court reasoned that choice conflict of law question did not matter, because these facts and the law governing uninsured Virginia lawyers' loyalty remained true no matter what a choice of law analysis decided with regard to which law to apply the counsel obligation. The court also determined that the crucial absence of a conflict of interest for Heard's insurer-appointed counsel would remain true regardless of what New York Marine's reservation of rights letter might say. No matter what it might have said about New York Marine's position vis-a-vis Heard, it says nothing about Heard's Virginia lawyer's loyalty to Heard. Heard's response to New York Marine's motion on the independent counsel obligation question is to argue that California law applies, and that an actual conflict of interest existed between Heard and the counsel New York Marine appointed. She cites to 5 cases as support for this argument. Remember that. With the exception of the 9th Circuit decision in Northern Insurers, as relates to the issue of the requirement of independent counsel in a situation such as this one, none of these cases were cited in the briefing presented to the court when it decided this issue in the traveler's action. Even putting aside the fact that it is the only one of the 5 stated cases that could potentially serve as binding precedent with respect to this court, Northern Insurance is unquestionable the best case for Heard on this point. Nevertheless, the court is not persuaded that the approach it took in the traveler's action was the wrong one. Though Heard asserts in a brief that, like Virginia, Washington law is clear that insurer-appointed defense counsel represents only the insured, not the insurer, and owes a duty of loyalty to the insured that has no exceptions, such that, like Virginia, Washington does not recognize the tripartite relationship between an insurer, insured, and defense counsel. There is no indication in the Ninth Circuit decision insurance and Ninth Circuit decision in Northern Insurance that the court was aware of Washington's stance on the tripartite relationship question when it issued its ruling, and the case is not precedent for issues not discussed or decided therein. So Miss Heard and her lawyers decided to put more or less all eggs in a basket on a case that's not precedent in this issue. The only reflection in the Ninth Circuit decisions on the scope or impact of Washington law was the conclusory comment that, under Washington law, the insurance company defendant fulfilled its duty to provide a defense when it hired a particular law firm, and under California law, it did not. In other words, the Ninth Circuit never openly contemplated that Washington lawyers representing insured in litigation occurring in Washington owed undivided loyalty to the insured. Beyond this limitation in the ruling, in reaching its decision in Northern Insurance, the Ninth Circuit identified the underlying concern as protection of the insured when its interests conflict with those of its insurer, and noted that California Cummings Rule and California Insurance Code paragraph 2860 accomplished such protection by requiring insurers to provide independent counsel when a conflict arises. Indeed, the Cummings decision itself makes clear that the right to independent counsel it recognized was founded on the predicate of the existence of a conflict of interest. Let's skip over a few parts here. But the whole point here is that New York Marine's interest did not conflict with Heard's, and the conflict had not arisen because Virginia counsel had no obligation to New York Marine while they were representing Heard. The same would have appeared to have been the case in the Northern Insurance litigation, assuming Heard is correct about Washington law being the same as Virginia law on this point. But the Ninth Circuit never dealt with or directly confronted that fact, explaining only that attorneys practicing in lawyers still must abide by local ethical rules and may be sanctioned for failing to do so. In essence, the Northern Insurance decision never explained why the Ninth Circuit believed that a conflict existed between Washington and California under the circumstances. This court believes that the appropriate boots-on-the-ground question in first attempting to unravel that issue is, to whom did Heard's appointed Virginia counsel owe their duties? The answer, under the Virginia law that governed the performance and expectations of those attorneys, was clearly only Heard. where there is no possibility of conflicted loyalty, the answer is the same under either Virginia or California law. There is no right to appointment of independent counsel. And unless Miss Heard can dig up until tomorrow a precedent that tells otherwise, her counterclaim is dead in the water. And I'm going to skip over because even though I like to gloat, there's no real there's no real enjoyment anymore, really. Now it's just more or less a statement of fact that everything Miss Heard touches goes to the crapper. But let's go to the conclusion. The court will dismiss Miss Heard's breach of contract counterclaim likely without a leave to amend. So more or less on Monday at 8:30, her counsels have one chance. The court will dismiss Heard's implied covenant counterclaim with leave to amend. So there is a tiny opening on her implied covenant counterclaim. The court need not resolve New York Marine's alternative request for a more definite statement, as that request appears to be moot. It denies New York Marine's alternative request to strike as to the language in paragraph 25 of the FACC, but grants that motion with leave to amend with respect to paragraph 7 to 16 of the FACC, with the exception of the last bullet point of paragraph 16, as to which the court grants the motion to strike without leave to amend. So that, in broad terms, is how Miss Heard, in her fight against her insurance company, her counterclaim is more or less gone in its entirety, which leaves New York Marine suing Heard. Lesson to you all: don't lie, don't make up stuff, and if you necessarily have to, don't write about it. This is not legal advice, it's common sense. Don't write down your crimes. And if you do, don't make false allegations, don't lie on the stand, don't make up stuff, don't drag an entire movement in the mud because you are an asshole who can't see other people's point of view. Miss Heard, you're a loser. And the sad part is, somehow you managed to convince a lot of people to go down with you. The history will not be nice towards Miss Heard or her current supporters. That's what I had for you. Until next day or the day after. Y'all have a nice day. I'll talk to you later.